say it was only President Jonathan that did not challenge the electoral outcome in court. All other presidential elections we have witnessed in this country from 1999 till date has always been a matter of context, before the judiciary. The current president himself, I think lost election 3 times, and for those 3 times he was at the Supreme Court. He was in court, challenging the electoral outcome. So it's part of the electoral process. It's there in the Act. It's also there in the Constitution. The Constitution even went ahead to make provision as to the number of months within which the matter, will be disposed at the Court of First Instance and then at the Supreme Court. So it is there in the Constitution. But what we are clamoring over time is that we should try as much as possible to organize an electoral system that is clearly fair, free and credible, that will really make the intervention of the judiciary to be very minimal, because election results are determined at the polling unit. It is the people that determine who governs them. The judiciary can only come to correct any irregularity in the announcement of the electoral outcome, but not that the judiciary will now be the one to determine who actually is the winner. It's only when there is irregularities, when the number of votes that you allegedly say to have gotten is not the requisite number that should, make you to be the winner. That is when the judiciary will come in to intervene in order to correct those anomalies, but not that the court will now become the majority citizen that will determine who governs a state or become the president of the country.
What we are hearing is that today's proceeding was commenced with the pre-hearing, where the ground rules will be set. All the litigants will agree on, for instance, methods of coming up with witnesses and filing of documents and how it could be accepted, and issues of objections when it could be raised and all that. Take us into the processes for pre-hearing before the main hearing itself commences.
Yes, you are very right. The pre-hearing session is actually a time to determine the schedule of the process. This is what we call case management. You are presiding over a case, there is election petition. You now want all the parties to agree on the modalities that will be adopted in the trial. How many witnesses do you have? How many minutes? What kind of minute that should be given to each witness? The document that will be admitted as exhibits. What is the process of admitting those documents? You agree? Then, if there is going to be any objection that will be raised by any of the parties, the modality of decision of the primary objection will also be determined. Do the court determine the primary objection by ruling, or take all the cases together and then at the end deal with the issue of primary objection that has been raised at the same time with the substantive matter? These are the kind of thing that will happen to this scheduling of the timetable of this proceeding is what will take place today. The court will lay down the ground rules, and the ground rules will be adhered by all the parties. They will make it that everyone must adhere. And then I think that the court always have sense of urgency in election petition matter. They will always insist that lawyers should comply and cooperate with the court, and even the witnesses and all that should cooperate, and all the parties should cooperate, so that they can dispose of this matter expeditiously. That understanding has to be brought to bear in today's proceeding. Everyone will understand the ground rules. So it is a rule setting that is actually going to take place today. It's called pre-hearing session. That is actually what is going to take place today.
You also called it case management. It tells you that the Court of Appeal, that's the Presidential Election Petition Court, has at the back of its mind the fact, like you mentioned, that it has 180 days to dispense with these cases, yes. 5 of them. So it must be mindful of time. So sometimes in the past, we have seen the tribunal sit during weekends, even on public holidays, with a view to meeting with this timeline. Are we likely going to see a similar thing this time around?
It's obvious that, almost everyone is clamoring that, why don't we actually conclude the trial and the process before we swear in the people who have been declared winners. But the law doesn't make that provision. When that law was made 6 months for election tribunal, petition tribunal, we have not yet deployed much of this technology in our electoral system. Everything used to be manual. And in that old law, you have to call witnesses from all polling units in order to actually affirm that you won election in any polling unit. But with the new act now that was made, and now dispense with all the issue of witnesses, now deal with the issue of certified true copies of the result. Now, when it is brought, it's acceptable. It doesn't have to come from all the polling unit agents and all that. So the dispensation of that, of all manner of witnesses, coming to give evidence, and then the deployment of technology where we have beavers, and then we have certified true copy from INEC. We shouldn't be, probably asking for so much time now, and all those laborious time that the courts used to engage themselves, weekend, even on Sundays, in order to get to the conclusion of the election matters. Now, I think that technology has actually reduced the workload, because you now tender document, and the court will rely on those bundle of documents that come from INEC, and then look at its documentary evidence. And issue of getting witnesses every time to come and be examined and cross-examined, which is what actually kills the time, would have been taken care of. So I don't think that this particular dispensation, we are trying this new act, that this is a major election that has taken place after the new electoral act. So you will see that it may not take as long as it used to be. That is my permutation. It will not be as laborious as it used to be, where you have all manner of witnesses, because the witnesses now would have been reduced. You bring document and court will take it. It doesn't have to be done by all the agents. One person alone can tender all the documents at once, and it's documentary. So matters are resolved easily and all that. So I don't think it will go through that laborious process that we're used to under the new act, because the new act itself has actually dispensed with a lot of those bottlenecks, that make a trial process to be very inconveniencing.
Okay, Tari Y. Barrister Bani, let's bring in our correspondent who's on ground live at the Presidential Election Petition Court in Abuja, Utibe Omoren, also our judiciary expert. Utibe, thank you so much for joining us. Bring us up to speed. The situation on ground at the Presidential Election Petition Court.
Thank you very much, Amechi. Right now, at the Court of Appeal, I just stepped out from the courtroom to be able to do this, because cameras about now are being restricted from having access into the courtroom and rolling as well. So the keeping you up to speed with what has happened earlier, we got here at about 7 a.m. By the time we got here, there were a number of lawyers already here in the court, because it's the first day of formal hearing. In fact, the tribunal, as it would want to be known, actually the Presidential Election Petition Court, the Court of Appeal, has consistently insisted that it is not a tribunal, it is a Presidential Election Petition Court. It was filled up as at 7 a.m. A lot of lawyers were already here. Outside the courtroom, we had a number of security operatives outside. The road leading to the court was barricaded off, and only those accredited to have access into the court actually were allowed inside the court. And we still, even when coming inside the court, had to wait outside the court for about 2 hours before the doors to the courtroom were opened and were allowed inside. As you would expect, the crowd had built up. Quite a number of people had come in, so there was a bit of struggle getting access inside the court. A number of lawyers, including senior lawyers, senior advocates of Nigeria, were complaining about the crowd management system that was adopted by the court. Well, I suspect that the court was actually waiting for security operatives from the SSS to arrive. I was able to, monitor what was going on. I stepped out of the courtroom. I was outside about 8:30. That's when operatives of state security services arrived, and they got access inside the court, went through the back door, did the necessary security checks, and then eventually the door was opened and people were allowed inside the court. So right now, we're waiting for the justices to come out. But so now all the lawyers, the senior lawyers representing all the parties in this case, or with different petitions before the Court of Appeal are already here, and we're waiting for proceedings to commence.
So inside the court, have you cited some of the major litigants to this case? The presidential candidates has any of them showed up to witness today's proceeding?
So far, none of the presidential candidates have showed up. Only their lawyers, the senior lawyers, are here. But we expect probably much later that they would come. It's common to have the parties represented, and not just by the lawyers, but in person as well. Whether political parties, you find the national chairman of the party or the national legal advisor always in court. And for the candidates, the candidate themselves most of the time. I still remember in 2019 that although we had just about 3 petitions that were filed initially, but one actually went into full trial until conclusion, and that's a petition of the PDP and Atiku Abubakar against Buhari and INEC. And Atiku wasn't in court in 2019, but his vice presidential candidate at the time, Peter Obi, who is currently a petitioner and also presidential candidate of the Labour Party, he was in court consistently in 2019. So it wouldn't be surprising to find him here in court today. But so far, no high-profile politician representing or any of the parties are in court.
Okay. The processes and procedure for pre-hearing about to commence. Initially, we thought it was to take off by 9 a.m., but it's unlikely now. Any inkling as to when the proceedings will actually start?
We're actually looking towards 10 a.m. for now, because we're past 9 a.m. It's about 24 minutes after 9 o'clock. And so far, nothing seems to suggest that it's going to start by 9:30. So hopefully by 10 o'clock, it should start. But whatever the case, be sure that we'll bring you up to speed with everything that is happening. Of course, I listened to you much earlier with your guest there in the studio. The issues you've laid out are quite accurate. It's a pre-hearing session. It starts with the ceremonial opening of the presidential election petition court. Of course, we know that 5 justices will be presiding over this case. The president of the Court of Appeal, Justice Dongba Memsan, will chair the panel, and naturally, she would present our inaugural address to the court, lawyers, welcoming the lawyers, welcoming the litigants, and welcoming the media, of course, to the proceedings, and of course, soliciting for utmost cooperation. That's what they always ask for, utmost cooperation from lawyers and all the parties involved, because as you have said earlier, we have 180 days to dispense this action, and that 180 days actually started counting from the day the petition was filed, which is 21 days after the election being complained about, February 25, 2023 election. So that time is already counting, and you're talking about 5 petitions before the presidential election petition court. So they're much more going to be constrained by time as against what we saw in 2019. The electoral acts and the rules, the civil procedural rules, which will be what will be applicable as far as the hearing of the petitions are concerned, are all laid out. And that's why the law provides that these pre-hearing sessions would have to take place where all the motions, interlocutory motions, which any of the petitioners intend to bring up, this is the moment, this is the time to bring up those motions. Why is it necessary that those things be dispensed within this period? Because naturally, in legal practice, as is obtainable in Nigeria, surprises spring up at any time. So most of the time, it's usually used as a delay tactic by the lawyers, especially on the side of the defense respondents as far as election petitions are concerned.
You recall what happened during the 2019 presidential election trial at the Supreme Court? The court declined to rule on any interlocutory injunction till the day of judgment. Everything will be consolidated, the ruling and the judgment. Same day. Are we likely going to have it same way this time around?
Correct, Amechi. So what happens is that once any motion, interlocutory motion, is moved, addresses would have to be filed. The other side would of course have to respond to it, file its counter affidavit to the interlocutory motions. The court would hear it, but it will reserve determination on those motions until the day of judgment. So you are correct, Amechi. It will be consolidated and dispense with a decision given on the day of judgment. So on the day of judgment, what happens is they first of all deal with all the interlocutory motions applications that have been filed. Whichever one is successful is upheld by the court, and whichever one fails naturally and proceeds for judgment. One of those interlocutory applications usually is a motion of preliminary objection seeking a dismissal of the petition, or any of the petitions, any of the 5 petitions. I expect that to be filed by any of the respondents, whether INEC, whether Bola Ahmed Tinubu or his party, the APC. So even when those applications seeking to dismiss the petitions are filed, the court will hear the arguments for which they are canvassing. The other side, of course, will put up its response to it. The petition would then be, the motion would then be reserved until the day of judgment. And what the court usually says is if the motion succeeds, then on the ruling, which is on the day of judgment, if it succeeds, then that means that the case dies a natural death. But if that motion for interlocutory junction or a preliminary objection, beg your pardon, seeking to dismiss the petition fails to succeed, then they'll go ahead to give their further explanations and reasons to the substantive matter itself and give a considered judgment at the end of the day.
Yeah, Otibe, you told us earlier about the huge crowd outside the premises. One, is there a detour for users across the Court of Appeal premises in Abuja? And tell us more about the crowd. Of course, supporters of the different political parties who want to be have a piece of the pie by at least staying close to the election petition court. And inside again, perhaps we are hearing that the PDP and its presidential candidate, they have filed a motion seeking the leave of the court to allow live transmission of proceedings. And of course, it may be one of the issues that may come up. If that is done, perhaps it may reduce the huge crowd thronging the premises to witness the trial.
Yes, I mentioned the crowd issue before. Somehow they were able to manage the situation outside the courtroom. Unfortunately, where I am now, if we could just pan the camera for you so you can see, we're just right now, this is the entrance of the court, but where the camera is positioned to now is where the road that leads to the gate of the courtroom. So as you can see, there are barely, anybody there, anybody coming in, just a few cars driving in and driving out. And that's because they've been able to manage the situation outside the gate so much, such that they've limited the number of people who can come into the courtroom. Besides, most of the people that really had to come into the courtroom were allowed access into the courtroom about 2 hours ago. And that's why you find some level of sanity out here. Where I am at the moment is the entrance to the court itself. That's the first door that you pass through before you get inside the court. And from this glass door, there is a metal scanner, another door that leads to the court area, the foyer. Then from the foyer, you get inside the court room itself. Yes, Amechi, you're correct. We've also interacted with some lawyers, and they've talked about, on the side of the petitioners, and they've talked about a motion which they want to request the court to allow live media coverage of the proceedings. We'll wait to see when that motion is moved and how the court will react, and how the other side also would react. But we know that on days such as this, on the ceremonial opening of the presidential election petition court, where the presiding justice, the president of the court, as they were in this case, will be here will arrive to give her inaugural address. It's usually beamed live. The 2019, I was here, we covered it live. That's the only part that we allowed to cover live. The rest of the hearing, going into the main pre-hearing and the trial itself, we weren't allowed to cover it live. But for the ceremonial opening of the proceedings, which is what we're expecting to happen any moment from now, we usually allow to cover it live. But so far, what they're telling us is that we may not be allowed to roll live visuals from inside the courtroom. We've just been allowed to take visuals. So our crew members are inside the court taking necessary visuals of the lawyers in the court. The justices are not there yet, and I guess once they step in, we would have to cut off our camera, except we are given authorization to do so. So as far as the live broadcast of these proceedings are concerned, that motion, we understand, is already before the registry of the court, will be brought up here during this pre-hearing session. The courts are usually quite conservative. We've talked about this live beaming of the proceedings even before today. In fact, the NBA had spoken about it. It will help give transparency. And Amechi, as you said, it will also help, decongest the court so that a lot of people could afford to sit in their homes or in their offices and watch the proceedings, which AIT, we have our equipment here on the ground to beam. So if that is possible, rest assured that all our audience, locally and internationally, can see the proceedings live on AIT. Amechi.
Just one question before we let you to go. A quick one, a reaction we expect from you. I presume because of the restrictions that other cases before the Court of Appeal may have been stood down just because of this presidential election petition case.
There are actually two courtrooms here at the Court of Appeal. In fact, this is the Abuja division of the Court of Appeal. Behind me, quite a distance, say about 10 meters away from me, is where the ceremonial court is. That's where the ceremonial events of the court, whether the start of the new legal year or a valedictory session for any of the justices retiring or deceased, that's where it takes place. Where I am now is where the courtroom, actually, where litigation takes place. So inside here are two court chambers. One of it is clearly marked Presidential Election Petition Court, and that's where my business and the business of today, or what we're discussing right now, would take place. But there's another courtroom just opposite that one, and that is the courtroom where other cases are likely to take place. But from the course list, which has already been pasted here on the notice of the court, what's prominently on the course list are the cases listed on the Presidential Election Petition Court for today, and those are the 5 petitions slated for pre-hearing. So okay. I doubt that is going to really significantly affect other cases. There are other justices here in this division that would take care of any other case, civil matters or criminal, that the Court of Appeal Abuja division may need to consider. But as far as the Presidential Election Petition Court, you also need to understand that the justices taking to preside on these cases are not necessarily resident in this division. They are justices, heads of divisions in different states who have been, carefully chosen to join the President of the Court of Appeal here. So I'm sure that the court, that's just basically administrative. It knows what to do to take care of those other appeals that probably would have to be heard expeditiously.
So it tells us very quickly that those 5 justices at the panel are the most experienced, the top hierarchy in terms of administration for the Court of Appeal?
Absolutely, there are. I mean, you still remember that in 2019, the presiding justice for the 2019 Presidential Election Petition Court, Justice Mohammed Garba, you remember him, one year later, he was elevated to the Supreme Court, and with 2 other justices as well were elevated to the Supreme Court. So usually when big matters such as this come up, you bring in justices with the most experience to come in, and that also helps to fast track the case. And that also helps in a situation where you find the senior lawyers, most of them who have years under their sleeves practicing law, but some of them are even contemporaries of these justices when they left law school, or perhaps even their juniors even. Sometimes it can be quite intimidating. So you need the very senior justices who know their onions to take charge of the proceedings to ensure that there's no hanky-panky on any side.
Okay.
And I just understand that Amechi, quickly, let me just add this, that the national chairman of the PDP is here. I understand he just arrived. The acting national chairman, I beg your pardon, he just arrived, and we're expecting other party leaders, as I said earlier, to also join. He's actually leaving. That means he's just coming to see how things is going on, and former governor of Adamawa State, so you're finding the shot as well, Bonnie Haruna, also here. So that's just the update I have for you, Amechi. I need to go back so nobody steals my seat.
Absolutely. Just we'll allow you to go back, and if there's any breaking news, we'll be too eager to bring you on to share with the rest of Nigeria. Thank you so much, Otiba Omoren, for giving us that.
Have a nice day. Thank you.
Okay, Barrister Obani, I want your response to the reports from our man at the Court of Appeal, Otiba Omoren.
It's obvious. I don't know whether that your reporter is a lawyer. If he is, he has given accurate account of what is happening at that court setting. But if he's not a lawyer, I don't think he needs to go back to law school. I think he has every knowledge about what is actually happening today at the tribunal in Abuja right there. He gave a very accurate account of what is transpiring there. And we're all hoping to see what will take place. I thought by now, as rightly pointed out, with every sense of urgency, we thought that the court should have started sitting right now. But they may have their reasons and taking their time in order to arrange everything and make sure that everything is in order. So wait for them.
So 5 cases before the presidential election petition court from different parties, and you have the defendants also lined up. Part of what they would decide to do on these case management processes will be how to deal with each of these cases. Perhaps consolidation at this stage may not be possible. What do you think?
Consolidation? No, I don't think so, because they all came separately. Unless if their reliefs are similar, you consolidate a case when parties are similar and then reliefs are also similar. I think that what the court will do most time is to dispense with some of the bottlenecks. As I said earlier, under the old act, you have to line up several witnesses, but the new act has dispensed with that. It deals now more with the issue of documentary evidence. So if you have all the CTCs, one person can single-handedly tender all that, and that dispenses with bringing witnesses who will now be examined in chief and cross-examined, which is one of the things that actually take time. But the new act now has reduced all that burden by making sure that documentary evidence can be tendered by appropriate person to dispense with so many witnesses that come to give evidence. As you rightly pointed out also,
before you proceed, that tells us that what we've seen in the past, where the justices who claim that litigants have dumped documents on them without bringing on witnesses to speak to them, will not arise this time around.
Yeah, it would not, because the new act now has allowed dumping. So provided it comes to the appropriate authority and it is a proper document that has a certification, public document, if it's certified, it can be admissible in evidence. So dumping may not be an issue this time, because that has been dispensed with. As you said, and as your reporter also pointed out, this is interlocutory stage, where all the interlocutory motions will be heard. But as rightly analyzed, they will reserve ruling when the matters have been concluded and everything now will be dealt with, at the same time. And how is it going to be dealt at the same time? First of all, rule on those objections or the primary motions to deal with them. If it fails, it fails. If it survives, it doesn't mean that there is no need of going to the substantive matter. And there are so many things there that have been filed. You remember that APC also challenged the competence of P2B to contest the election. That he has, some legal disability and all that. Those things also will be dispensed before the substantive matter, is dealt with. So if it succeeds, it doesn't mean there is no need of going to the substantive matter. If Obi is not qualified, then you can look at the substance of his matter. The same thing with Tinubu. If Tinubu is not qualified in the first place to have contested election and all that, then you don't need to go into the substance, whether he even secured 2/3 of all the states of the federation, including Abuja and all that. So it's going to be an interesting period in our life. But what everyone is insisting and clamoring for and praying for is that let us have a judiciary that is very bold, let's have a judiciary that is interested in, enthroning justice. Let us also have a judiciary that is interested in not overruling the mandate of the people, but upholding the law. Where there is a law to be upheld, please, when the law says this man is not qualified and he have all the ingredients that disqualify that individual, you don't need to look at face. You don't look at any person. That person should be declared disqualified. That is what happened in Kenya recently, when the court had to determine also the electoral process. They exhibited some level of boldness. So there are areas for us to show boldness and apply the law as the law is. Don't look at any face, and don't bring issue of political consideration. Oh, because if you remove this person now, it's going to create crisis and all that. For God's sake, if he's not qualified, it's not qualified.
What of Sobani? The issue of we have seen in the past where the courts will tell us we are moving away from technicalities to dispensing justice. We are likely to hear cases brought before us, whether they come in through the door, through the roof, or through the window. We must dispense justice. But later, of recent, we are seeing judgments based on technicalities. How will you speak to these two parallels, as it were?
Yes, there has been a departure by the Supreme Court over time that they will not adhere to technicalities, that they would rather uphold the principles of substantial justice. And that sits well with everyone, because people are interested in substantial justice, rather than technicalities. But at times, again, you see where you think that the court itself has actually committed an error. But it's important that at any time you feel that they may have adhered to technicality, you must also go through the judgment, because most times people come away and make some spurious allegation against it without looking at the judgment in itself. Let me just give you an example of Akpabio's case. How Akpabio emerged as a senatorial candidate of APC and then eventually won the election. A lot of people have not read the judgment of that particular Supreme Court, that made Akpabio to emerge. And most people who comment, oh, I did not. The point is, the man who took him to court said that there was a primary election, and that primary election was not conducted by the National Working Committee, rather by the political leadership of the party in the state. And the state political party leadership does not conduct election under the Electoral Act, and even under the rules, and even the constitution of the political party. So people do not look at, and there are so many other mistakes that were done. He even said election took place in a day that was not decided by the political party. He said election took place on 27th of May, whereas senatorial primary election took place on 28th. So these are issues. So, but when people do not read these things and go into this, and they begin to criticize, oh, there was no election, the court has used technicality. So I think that most times also we should be a bit more, more sensitive, when criticizing the judiciary, especially when they read the case, go through the decision and look at their reason. If they have actually upheld technicality, we will know and then criticize them. But if they have also upheld the law, we must also be fair in our criticisms, So sometimes, making a blanket statement over something that happened in judiciary may not certainly most times be accurate. That's I just want to say this. So I'm saying that the court must be bold enough to really dispense justice, substantial justice, and not technicality. And people are watching. People are, and that's why people are saying that it should be open hearing. Let this thing be televised. I mean, we borrowed this particular practice from Britain. As I speak to you today, people observe proceedings in Britain. People, through television, through this and another. In America, we see them whenever the court is seated. We see what goes on. Everyone watches the proceeding. We monitor it daily. So why is it here we are making sure that everything is secret? So why the level of secrecy and all that? So I believe that this application that has been made by a PDP, that this particular hearing be open, that the court will accede to it, because if they have nothing to hide, this is the time for us to make an advancement in our judicial process, in our jurisprudence, by saying we can now begin to watch very important political cases, or even criminal cases openly. Let everyone sit in his home and watch it and enjoy it. And Nigeria will begin to be reckoned as a country that is making progress. That is not, close-knitted. That, always cover. Let us not cover this particular proceeding. Let's make it open and let the whole world see that Nigeria has actually made some level of advancement in our electoral journey. That is my advice.
I got that, Barrister Bani, that you've been doing a lot of research, in fact, almost gathering your thoughts in form of a book as to election petition cases in Nigeria. Quickly take us through some of your findings.
Yes, my I will deliver a lecture in South Africa, in June, sometime in June or July. African Bar Association will be having their conference in Joburg. And so I want to deliver a lecture on the issue of judicial intervention in our election journey, in our electoral process. And then how far that journey has been, where judiciary has actually played a very good role in balancing, the equation and making sure that the polity is not destroyed, and some of the cases also where the judiciary itself actually, failed the people by substituting the majority with their own minority. Of course, what happened in Bayelsa, where somebody who won an election lost that election because, according to the Supreme Court, his deputy was not qualified and all that, and there are other cases also of in Imo, where everyone knows that it was said that number 4 became number 1. So these are some of the things that has happened in our electoral journey, where the judiciary is actually brought into to intervene, and what manner of intervention did the people live with a very sweet taste in their mouth, or was it with a sour taste? So these are some of the things I will consider in then making my recommendation. To what extent do we have to really believe and rely on judiciary to be the one to be the final arbiter on our electoral process? Are they doing it right? If they don't do it right, what more input are we going to make in terms of law to correct the mistake, so that the judiciary does not in any way put us into chaos, by their intervention? Yeah, they have the final say. That is what the law has said. But is there anyone watching the judiciary too, especially when they make that mistake, that will really, give a different opinion of what the majority has actually said? This is supposed to be our leader. Recruitment of leadership is key. And in making sure that who emerges as leader, the fairness and process of that emergence must be very critical, because that also accounts for responsibility and accountability in governance. If somebody does not feel that you have elected him, he will not owe you responsibility, he will not owe you any accountability. But when he feels that you have an input in him becoming a governor or president, he owes you, he becomes sensitive to all your needs and aspirations. So getting the kind of system that will ensure that whoever the people have chosen becomes the ruler is very, very critical. So getting judiciary that can truncate that process is something that we have to also look at and make sure that
you mentioned the issue of Imo governorship election that brought in Hope Uzodinma as one of the points you raised in the lecture you're going to deliver in South Africa. I recall one of the justices, in fact, one of the justices that wrote the minority judgment expressed concern that majority judgment may haunt the Supreme Court for a long time. Since then, it's been on the front burner. The case has not rested, as it were. People are still making reference to it. So some may reach that conclusion that his prediction is coming to pass, and there's always need for courts to come up with such judgments that will come back decades to haunt it.
So that is a very sound and profound one. We need to be careful. That's what we're saying. Who watches the judiciary? Now we have made judiciary the last arbiter in our electoral process. Now who watches the judiciary in case of any error they have committed? Are we going to leave it to history now to be the judge? Are we going to leave it that it haunts them for life and all that? Wouldn't there be an intervention by a policy to say, okay, if the judiciary makes a mistake, how do we correct them? So this is an area we should be looking at. So it's a very very deep thought, you have just expressed this morning concerning what happened in the Imo case, where people were saying that it was not right for what the Supreme Court did, because that was clearly setting aside of the mandate of majority, because the people chose somebody, but due to some level of technicality that was employed in that judgment, somebody who was not supposed to be the governor eventually emerged as the governor. And that wasn't something that everyone was happy about, So we need now to begin to look at those errors that can be committed, because the justices are human beings. They are not God. They can also make mistakes. They are not final because they are So there are human beings that can also be subject to some level of fallibility. So what do we do to ensure that when they become fallible, that something else will be done to correct that fallibility? So there must be another layer, maybe, in order to checkmate, or maybe through criticism also. The human beings, let them also look at what people are saying, read what people are saying, and be careful. Because when they are also sitting on trial, they're on trial. People are watching them, and then if they do it wrongly and all that, they can also be judge and judge rightly too. So they must be careful in whatever they do. That's why we're saying that this current thing that is happening now, starting today, judiciary must know, as it sits there to hear cases and try these cases, they are on trial. They are on trial. And what they will do is to ensure that justice is actually upheld. And there is nothing wrong in for them to open this particular proceeding for everyone to observe, to see whether what they are doing actually accord with the law, which everyone knows has been there from beginning. We have the Electoral Act, we have the Electoral Guideline, we have INEC Guideline, we have the Constitution itself. Was there compliance with all these three laws? In this election that took place in 2023, was there adherence to it? And if there's no adherence, what is the court supposed to do in this circumstance? Would they be bold enough to say, no, we didn't get it right here? This is the way it's supposed to have been.
We have to thank you so much, Barrister Mondo Bani, for giving us those incisive analyses of election petition issues in Nigeria's electoral process. Thank you so much for joining us this morning.
Thank you for having me. Good morning.
That's the end of the program for today. My name is Amechi Anakwe. Thank you so much for joining us today. Focus Nigeria is next. Do stay tuned.
Did you know that AIT's social media handles have all changed? If you are one of the millions of our followers on Facebook, Twitter, and YouTube, this is introducing to you AIT's new official and rebranded social media handles. Like or follow us now on our Facebook page, Official AIT Live. If you're on Twitter, switch to our new handle at Official AIT Live and activate the notification button to get breaking news and updates on the go. For exclusive short videos and photo news, follow our Instagram account at Official AIT Live. Subscribe to our YouTube channel, Official AIT Live, and enjoy live streaming of news and your favorite programs, where you can also watch our broadcast materials at your own convenience. Note that Official AIT Live is the only authentic social media profile name with all the handles on our website ait.live, with a notification prompt to accept and receive breaking news and updates on the go. Log on to Facebook, Twitter, Instagram, and YouTube platforms on your smartphone, tablet device, laptop, and desktop to follow us now. AIT.live. On air, online, on live.